Mora. Appellee Kathleen Lovell is self-represented and is appearing by phone.
Thank you very much, and good morning, council, and good morning, Ms. Lovell. Can you hear me, Ms. Lovell?
I can hear your voice, yes.
All right, and we can hear you, so we'll first turn to counsel for the appellant. Please introduce yourself, identify your client, and then proceed.
Good morning, and may it please the court. Attorney Francis Demora for appellant Brian Tomlinson.
Thank you.
This case is about the line that separates legitimate citizen oversight of public officials from citizen overreach that threatens violence against those officials to settle perceived wrongs. Kathleen Lovell crossed that line while waging a years-long campaign against Brian Tomlinson, who is a patrol officer with the Morristown Police Department. That campaign reached its violent pitch last May when Lovell threatened to shoot Tomlinson's wife and kids. Tomlinson first encountered Lovell in April 2023 as an officer responding to a call about an incident involving Lovell's son. Since then, Lovell has persistently attacked Tomlinson online, including to accuse him of having tried to kill Lovell's son. The post Lovell made...
Is there a difference between an actual threat and a perceived threat?
The civil anti-stalking statute does not require that a threat be overt, and a true threat does not need to be overt. It has to be a serious expression of an unlawful act of violence. And that's exactly what happened on May 4th, 2025, when Kathleen Lovell posted the following. Brian, I hope someday that someone fires 80 40 caliber bullets into your wife or kids. I hope someday a thug commits extreme violence against your wife and her possessions. The specification of the make of caliber indicates an intent to commit an unlawful act of violence, and Mr. Tomlinson would submit is a true threat not protected by the First Amendment.
Why though? There's a highly deferential standard of review here, or a deferential, I should say, standard of review. How do you from your point of view, why should that compel us to reverse a trial court's decision?
Thank you, Your Honor. As the court did in both Hinkson versus Stevens and Morton versus Young, two cases examining the civil anti-stalking statute, the court should apply de novo review to the trial court's interpretation of the civil anti-stalking statute. We are not requesting that the court revisit the trial court's factual findings, only its conclusions about the application of the civil anti-stalking statute to the facts present here.
Does it matter that the incidents that you referenced were expressed as a hope rather than as an affirmative, unqualified statement?
Mr. Tomlinson would submit no, and in fact, this court earlier this year in Nichols versus Lafayette did not find that hopeful language significant when affirming a trial court's decision that a statement by a parent that he hoped a school superintendent would get hit by a bus constituted a true threat. So that May 4th post was the zenith, the most, what Tomlinson found to be the most disturbing, most violent post, and one of two necessary predicate acts to establish stalking. The other act of stalking is monitoring, and that act is evidenced by Lovell's multiple social media posts between September 2024 and May 2025, where Lovell demonstrated that they had collected information about Tomlinson's private life. As this court said in Hinkson versus Stevens, monitoring in this context involves tracking or collecting some form of information about the person being monitored or their activities. The trial court found no evidence of monitoring.
Mr. Demora, if a court made a finding that obsessive behavior poses, can the court make a finding that obsessive behavior poses a potential risk, that the risk factors are high?
Well, they'd have to.
You have 1 minute, counsel. 1 minute.
Thank you, Your Honor. They'd have to make that jive with the requirements of the civil anti-stalking statute and its definition of stalking, which is the purposeful engagement in a course of conduct being two or more acts, however close in time of, for present purposes, monitoring or threatening. Here, Tomlinson submits that Lovell's persistent posts, Lovell posted about 70 times between September 2024 and May 2025, demonstrates that obsessive behavior. The fact that her comments were infused with details of Mr. Tomlinson's private life that Tomlinson never shared with Lovell, and Lovell had to make some effort to gather, demonstrates that she was collecting information unavailable to the public and thus was monitoring Mr. Tomlinson over that period. Together with that May 4th, I'm sorry, Your Honor, go ahead.
I think I'm about to ask the question you're about to answer, which was your position then is that there's the true threat being one incident and the monitoring being the second.
Yes, Your Honor, that's correct. The trial court found that there was no monitoring because Tomlinson didn't show how Lovell had come across that information. But that's not what the civil anti-stalking statute requires. Instead, what matters is that Lovell collected the information about Tomlin's family, their extracurriculars, even his old job as a chef. Lovell didn't intuit that information.
Okay, your time has expired. Thank you very much. Ms. Lovell, can you hear me still?
I was on mute. Sorry. Yes, I can hear you.
All right, please go ahead.
In April 2023, Brian Tomlinson left his body cam off and shot at an unarmed autistic kid several times while chasing him in an apparent attempt to kill the autistic victim. Brian Tomlinson attested that he was shot through his clothing, resulting in 3 bloody injuries. The Vermont Attorney General Office concluded that Brian Tomlinson had not been injured. Brian Tomlinson lied. Images of Brian Tomlinson's clothing show no damage to the clothing. Brian Tomlinson lied. Brian Tomlinson claims that he was shot multiple times by the victim. The shotgun that was recovered is incapable of firing more than one time. Brian Tomlinson lied. In short, Brian Tomlinson chose to leave his body-worn camera off so that he could kill an unarmed man. Off the record, Brian Tomlinson then lied under oath about what occurred. The victim has been held in jail to this day based off these lies. Brian Tomlinson has committed perjury with irreparable harm resulting. The publicity from Brian Tomlinson's lies has had severe societal impacts on Kathleen Lovell, who is the parent of the autistic victim and a longtime resident of the town of Morristown, which is the employer of Brian Tomlinson. With legitimate concerns about Brian Tomlinson's criminal behavior, Kathleen Lovell communicated with the town of Morristown several times by email. These emails are referenced in the trial court transcript, printed case page 75, 76, 85, and 86. The town responded to Kathleen Lovell's concerns by using public funds to pay a law firm to craft a lawsuit against Kathleen Lovell on Brian Tomlinson's behalf. The trial court granted an ex parte emergency order which threatened Kathleen Lovell with incarceration for voicing these concerns of Brian Tomlinson's criminal behavior. At the trial court hearing, Brian Tomlinson was represented by 3 attorneys and had 2 witnesses in a hearing that lasted 2.5 hours. Despite these ample resources and opportunities to authenticate his evidence, Brian Tomlinson failed to do so, and the trial court's factual findings reflect this failure. In Brian Tomlinson's brief, page 4, Brian Tomlinson claims no error with these findings of the trial court. Therefore, Brian Tomlinson agrees with the trial court's factual finding that his evidence has no connection to Kathleen Lovell. Kathleen Lovell is not a party to this action. This case needs to be dismissed. Kathleen Lovell objects to Brian Tomlinson's request for remand. Brian Tomlinson's failure to authenticate his own evidence is not a legitimate reason to remand. In his Exhibit 10, Brian Tomlinson claims that a reference to your wife or kids constitutes a course of conduct directed at him. Course of conduct in this statute is directed at a specific person. Brian Tomlinson, given the clear option on the original complaint, did not seek an order for kids. Statute does not allow Brian Tomlinson to seek an order for his adult wife. The judge described Exhibit 10 as a reciprocal to Brian Tomlinson's violence. Brian Tomlinson's act of violence was deemed lawful by the Attorney General. Therefore, Exhibit 10 does not express an unlawful act of violence directed at Brian Tomlinson as required by statute. Asked whether Exhibit 10 expressed intent to harm, Brian Tomlinson responded, "Who's to say?" Printed case, page 168, line 16. In summation, Brian Tomlinson's evidence was found to have no connection to Kathleen Lovell, and so this case needs to be dismissed. Brian Tomlinson additionally failed to show that his evidence conveyed a course of conduct directed specifically at him, and so this case needs to be dismissed. I'm finished.
Okay. The appellant has no time, am I right?
That is correct. Appellant has no time remaining.
Please call a conclusion of the hearing.
The next hearing for the court is